Welcome back to our virtual orientation for the English Language JD program at the University of Ottawa. In this podcast, we turn our attention to legal history. And by legal history, we really mean two things. First, as an introduction, I'll provide you with some insight and observations about the history of the English legal system inherited by the Canadian common law provinces. I will then interview Professor Constance Backhouse, discussing the relevance of legal history to your legal studies and to your understanding of the law, with a focus on how legal history informs not just past understandings of the law, but is useful for understanding how the law may be shaped in the future. Turning then first to the history of the common law system. The common law is inherited from the United Kingdom, and while it is possible to spend an extended period of time describing the origins of that system in the United Kingdom itself, what I shall do in this podcast is to give a brief summary of the emergence of the common law system in the medieval and early modern period in the United Kingdom. The first point that you need to understand is that in the common law tradition, courts, and specifically common law courts, are themselves lawgivers. In other words, they are the source of law, and historically, probably the most important source of law. And certainly in private law relations, and in fact, in modern Canadian common law jurisdictions, the common law remains a major, if not principal, source of rules. The emergence of common law really stems from the politics of power in early medieval England. And so when Saxon England was conquered by William the Conqueror in 1066, and a system of Norman French feudalism was introduced into England, this was a system in which the king subdivided the land to the king's barons, who would then subdivide the land further to their underlings, etc., etc. Now, this history is important in understanding real property, but it is also of significance in the development of the English legal system. Initially, justice was bestowed by so-called manorial courts, courts of the manor, and these were courts of the local lord who held the land and were designed to deal with disputes amongst the tenants who occupied that land. And the laws that these courts applied was very primitive. It often involved ordeals or rights of battle. The years passed, and eventually English monarchs came to the throne who were inclined to centralize power. And so to strengthen their hands, they created a new and competing system of courts known as royal courts. These royal courts were the only ones that could deal with some disputes, excluding, therefore, the application of law in these areas by the manorial courts. And these courts became more accessible, these royal courts became more accessible to the people by ensuring that they traveled around the country in circuits. Now, in order to get in front of these royal courts, you needed a writ. And a writ was originally a letter from the monarch ordering a person to do something. With the passage of time, writs became more formal, and the chancellor, who was essentially the royal secretary, would pre-prepare writs, leaving only the names blank. And these different sorts of writs were designed to deal with different sorts of disputes. And if there was a new sort or type of complaint, the chancellor would develop a new writ. And if you didn't have the right sort of writ, you would lose on procedural grounds in the royal courts. So what did these royal courts do? Well, for one thing, because they were nationwide, they were the first courts to apply unified rules. They applied rules that were common to all the people of England. They became common law courts. Now, these courts weren't supposed to make up rules. They were supposed to apply pre-existing Norman and Anglo-Saxon customs, but these customs weren't written down, unlike in the Roman or civil law system that developed on the European continent. So while in theory the royal courts were there simply to declare pre-existing custom, in practice these courts would come up with new traditions and customs to cover new situations. Nevertheless, the myth, the legal fiction, was that they were merely giving voice to a principle that was already in existence. While a myth, this doctrine served as a constraint on how creative the common law courts could be, how liberal they could be in unearthing these so-called pre-existing customs and rules. An aspect of this limit was the need for certainty, the need for predictability. Parties to a dispute had to be able to predict with some measure of certainty the outcome. The exercise of court power could not be arbitrary. Now, if the law is written down, certainty comes from a written code. But if it's not, what then? Well, here arose the notion of precedent, or to use the Latin expression, stare decisis. The rule arose that common law courts were to follow precedent. Litigants were to be able to predict what is likely to happen by looking at what happened in similar past cases. And just as the judges would determine which precedents they were bound by, the litigant too could inspect these precedents, bring them to the attention of the judge, show how this precedent applied to the facts in the case. But there was also flexibility in the system, because the judge could determine that the precedent did not apply, that the facts were not sufficiently similar, and that the case before the judge could be, to use the parlance, distinguished. Now, in the to and fro between the monarchs and the English barons, in terms of the power struggle that animated early English society, there were efforts to undercut or undermine the authority of the royal courts in favor of these manorial courts. And so, for some time, there was a moratorium on new writs being developed by the Chancellor for new types of legal complaints or new so-called causes of action. And so, as the writ system began to break down, the common law system became progressively more and more moribund, to the point that by the 14th century, the common law courts were stagnant and thrived on technicalities and not justice. In these circumstances, something had to give. The monarch still had the power to hear disputes, an inherent power possessed by the monarch, and the task of resolving these disputes was not entirely left to the courts. People began coming to the monarch looking for justice where the common law courts had failed them. And the monarch eventually gave the task of hearing these complaints to the Chancellor. Eventually, the hearing of these complaints by the Chancellor became formalized by the time of Henry VII into something known as the Court of Chancery. And this court was designed to give relief for the rigidities of the common law courts. It administered a form of law known as equity. And what was equity? Well, at the beginning, equity was law without rules. It was driven by a concern for fairness and justice. Because there were no rules, and the Chancery basically resolved disputes according to what it saw as fair, the Court of Chancery was heavily criticized. It was said that the justice dispensed by this court was unpredictable and variable and depended on the judge who heard the matter. There was no doctrine of stare decisis, no doctrine of precedent. The rules of equity, it was said, varied with the size of the chancellor's foot. In other words, they were as variable as the different shoe sizes of the different judges who heard the cases. Of course, having two different systems of justice produced the prospect of conflict between the courts. A doctrine emerged that gave equity primacy over the common law in the event of conflict. Time passes and much happens in terms of English history, in terms of the development of Parliament, matters which we will discuss in another podcast. Common law courts eventually come to apply not only the common law rules developed by the courts themselves, but also apply laws introduced by Parliament. And they also interpret the common law to restrict some of the powers of the monarch, recognizing ultimately that Parliament is supreme, the doctrine of parliamentary supremacy, which is an important, indeed elemental aspect of public law discussed in another podcast. We get to the 19th century, and at this juncture, we see reform in both the common law and courts of equity. In the early 19th century, the vast majority of writs are abolished and procedures in the courts are simplified, and the flexibility of the common law approach is reintroduced. The distinction between equity and common law begins to blur as each court applies doctrine from the other. And in fact, in the United Kingdom, in 1873, the common law and equity courts are unified, though the two bodies of law remain relatively distinct, albeit heavily influenced one by the other. That is essentially the system we have today in Canada, at least in the provinces other than Quebec. And so how did it come to Canada? The simple answer is that we adopted English common law because Canada was a British colony. And the actual mechanisms by which common law was introduced in Canada varied from region to region. In Ontario, the legislature of Upper Canada was created by the Constitutional Act of 1791, and that legislature passed its first statute in 1792. This statute essentially received English common law and equity. And so English common law and equity are deemed to have been received in Ontario as of the 15th of October, 1792. And then in 1881 in Ontario, the equity and common law court systems were fused, much as had happened in the United Kingdom in the prior decade. And so to come back to this concept of common law, what does it mean? Well, the term common law means different things in different contexts. In early history, it was common law as opposed to manorial law, the justice bestowed by the royal courts, common to all of England, as opposed to the idiosyncratic justice bestowed by the barons' manorial law. Common law also is distinguished from equity. In other words, the law produced by the common law courts versus the law that was generated by the courts of equity. And then in later history, it's common law as opposed to statutes. And so common law, the law unearthed and then applied through the doctrine of precedent or stare decisis by the common law courts, as opposed to the law prescribed by the legislature in the form of statutes. And so in this manner, common law has a highly variable meaning, but in all instances, we are preoccupied with judge-made law. Now, I should alert you to one other aspect in which the term common law has significance in the Canadian legal parlance. As I've noted, all the provinces, except for Quebec, inherit this United Kingdom judicial tradition. Quebec, on the other hand, inherits what's known as a civil law tradition. Civil law has its origins ultimately in Roman law and becomes the dominant species of law on the European continent. And so one other way in which the term common law is used in Canadian legal parlance is to distinguish between the common law provinces, that is, those provinces that inherited this judge-made law concept from the United Kingdom, as opposed to Quebec, which is a recipient of a civil tradition. One note, however, on the use of the term civil law. Civil law can refer to that European continental tradition, but there is also a concept of civil law that is a subset of common law. When we talk about civil law as common law lawyers, we generally mean that law that governs relations between individuals, sometimes otherwise known as private law. And so that is why we talk about civil actions brought in tort, for instance, or a civil action for a breach of contract. And so just be aware of this ever-mutable terminology, otherwise it will be enormously confusing. And just to further reinforce your understanding in this area, we shall have a podcast on the Quebec civil law tradition so that you further understand how it differs from the common law system upon which you focus in your JD studies. So let me end this very brief discussion of the history of common law by summarizing 3 key points about the common law system of judge-made law. And so recall that common law judges are lawmakers, but they make law by supposedly unearthing customs and rules. They are not supposed to invent new principles from the ether. And common law judges ensure consistency, continuity, and certainty in the law by abiding by the doctrine of precedent, that is, the concept of stare decisis. Common law courts, however, amend the law they make in this manner by distinguishing, reinterpreting, or overhauling past decisions, and by reinterpreting perhaps the requirements of precedent and stare decisis and the extent to which they are bound by their own past decisions. In this manner, the common law is highly flexible and highly fluid. And it has evolved enormously with the passage of time to reflect new social mores and new concepts and principles that animate the Canadian society. And with that in mind, I wish now to turn to an interview with Professor Constance Backhouse, discussing how legal history can provide insight in understanding the fluid and sometimes quite unsatisfactory nature of the justice bestowed by Canadian law.